and listen to all the good news we have on legislature and policing. Steffens, I think with me consenting that being recorded, that we're being recorded, right?
Absolutely.
Boy, he's sharp tonight. Okay, that was me, not you. Okay, I'd like to call to order the City of Sumner City Council study session. The date is the 28th of June. The time is 6 p.m. and the temperature outside is 106. So bless all of you that are home without AC and you're still weathering the storm. I feel your pain. I came to City Hall specifically to escape it. So I would note that City Hall obviously remains closed during Governor Inslee's Healthy Washington Recovery Roadmap Order, consequence of the COVID-19 pandemic. And the public has been invited to attend this meeting virtually by using the Zoom meeting access information that's on the council agenda and on the city's website. Without, again, note all council members are present, and we will move into regular business. We have two items before us on regular business. The first one has to do with impacts from the 2021 legislative session on policing policies and practices, a nice light topic tonight. And with that, I will turn it over to City Administrator Jason Wilson. Mr. Wilson.
Thank you, Mayor. The chief tonight, as the mayor said from the topic title, we'll be discussing a number of changes that the state legislature made during their session. We typically would combine all these into one report to council, but because of the sheer volume of the police reform bills, we felt it was more important to spend a little extra time going through each one of those, outlining the impacts that we know about and those that are potentially still out there. So with that, I'll turn it over to Chief Murky, and City Attorney Marquez will probably also chime in from time to time.
Thank you, Jason. Mayor, council members. You recall back on May 24th, Carmen and Bill Clark gave a very eloquent update to the council regarding some of the positive things and some of the things that Sumner requested were approved in the last legislative session. Tonight, unfortunately, you're going to listen to me quite a bit. I apologize. But tonight I'll be updating you on the many policy and practices implications of the 13 bills passed by the legislature and signed into law by the governor this past session. I apologize if I have any technological problems. Hopefully you can all see that okay? Yes, okay, got the thumbs up from the mayor. Probably one of the first, one of the biggest, two of the biggest bills are the police tactics bill and the police use of force bill. HB 1054 police tactics bill prohibits the use of chokeholds or neck restraints, the lateral vascular neck restraint in any circumstance. As you recall, Sumner, or I banned the practice last June for 90 days, and then after studying the issue, permanently removed it from our policy in September of last year. It also prohibits and limits the use of tear gas, does not specifically limit the use of pepper spray, oil resin, caps gun, which is what most of our patrol officers carry as a less lethal option. However, OC or tear gas is still carried and used by many of our tactical teams, including our regional tactical team, and it's still authorized in very limited circumstances in hostage or barricaded subjects. Very limited in use of riots, must be approved by the highest elected official, and that was a consequence of a lot of riot activity in the city of Seattle this last year. It bans use of military equipment. That definition is not necessarily what you'd think, is in whether or not you acquired it from the military. It's much broader than that. Includes automatic weapons, of which we currently still have one that one of our former tactical team officers has been using. We'll need to divest ourselves of that. And then there was quite a bit of controversy, and Andrea's weighed in quite a bit on this in her legal circles about there's a prohibition against having any munition that's larger than 50 caliber in diameter. And our 12 gauge shotguns are less lethal projectile. launchers. They are greater than 50 caliber in diameter, but they're measured differently, like 12 gauge and the 40 millimeter launcher. Those would, under strict reading, be banned. However, I think that's contrary to the legislative intent that we increase use and availability of less lethal options for our officers. All police officers must be readily identifiable. That, of course, is already done both by name and badge number in our department. This is probably the biggest impact in most jurisdictions throughout Washington, is it extremely limits vehicle pursuits. You must have probable cause. And I underline that because that's a higher standard than what would normally be required. You have to have probable cause that the person in the vehicle has committed or is committing a violent offense. And so you'd have to have enough quantum of proof, probable cause, to be able to arrest that person. And that's not always immediately known to an officer when they're responding to a scene, a report of a robbery at the Bank of America, and they fled in a red vehicle. Officers would be able to, if they had reasonable suspicion, would have enough quantum of evidence to initiate a stop on the vehicle. Anyway, so it's a much higher quantum of evidence. We'll see that as well under the use of force bill. And it limits it to a violent offense. That's not typical. It's much more restrictive than what most people would consider a violent offense. So it does not include 4th degree assault, even domestic violence assault. Doesn't include assault in a 3rd degree, which is a felony. Any property crimes whatsoever, even theft of firearms, of course, stolen motor vehicles, residential burglaries. You are not allowed to pursue any of those, even if you have probable cause to make an arrest. It's restricted to basically Class A and Class B serious felony offenses that are person offenses and not property offenses. Or you can also, the legislature, because of the public safety implications, allowed reasonable suspicion of driving under the influence. Again, that's the lower standard that typically applied. They're leaving that standard for driving under the influence cases. And it's also not only the violent offense, but in prevent and escape. So those are the 3 instances in which you may, but the other limitations in the bill also still have to be present. The officer must have authorization to initiate the pursuit from a supervising officer that's present and has supervisory control over the pursuit. There's a very limited exception to that for agencies that employ 10 or less officers, because the legislature understood not all those agencies have supervisors or supervising officers available. That's going to be fairly problematic for those departments like ours that are these mid-size, and the majority of law enforcement agencies in the state are fewer than 50 sworn, and not all of those have 24/7 supervision. And there's a third element that must be present, in that the officer must engage, or the supervising officer must engage in analysis and demonstrate that the failure to apprehend the driver presents more of an imminent threat to public safety than what's caused by the pursuit. Our policy is fairly restrictive as it is now, and also has similar language. We don't want to create a greater danger to our community. And it also prohibits firing a weapon at a moving vehicle, with a very narrow exception of if there's an imminent threat, and that does not include the vehicle itself, i.e. a vehicle heading towards an officer. Somebody, yeah.
Just a second. Charlotte asked a question. Go ahead, Charlotte.
Oh, I'm sorry.
No, don't be. I don't know. For me, it's easier to go slide by slide, but I don't know if that's disruptive. Like, I can do either. But I have a couple of questions. One is regarding the need to divest, the question about divesting of an automatic rifle. I am now, with the influx of mass shootings, I can understand why it might be necessary, but I'm not on public safety committee. And so I'm curious about like, how many do we currently have and when is the last time, like who carries them? Like, how are they used or when are they carried? And when is the last time, if ever, that we've used one?
So we only have, all of our officers are issued semi-automatic rifles. It just so happened probably from the early 2000s, one of our Detective Nicolau was on our SWAT team and our methamphetamine joint task force we had, and he has a gun that's capable of firing automatically, and that is strictly prohibited under the bill. So that's only one item we're going to have to divest of. And we'll probably do so by destroying it. Does that answer your
Okay.
question?
Yeah, no, it does.
And one of the other requirements in the bill, and again, I have really condensed this down for you folks, or we would be here till close to midnight. So one of the other requirements in the bill is that every law enforcement agency has to report to WASPIC by November 1st of this year, a list of any military equipment that's currently in their possession. And exactly that. When was it last used? Why do you need it? So the legislature's really, they realize, and then they have to divest themselves by December of 2022. So there's one more legislative session between now and then. So I think the legislature is really trying to get a handle on, what are the true impacts. And if you read the bill, it's got some fairly, grenades, launcher, missiles. I mean, things that no law enforcement agency in this state uses.
So we don't have a tank that we need to put on the
No.
public auction circuit? Okay.
No.
Thanks.
All right, this is the next rather expansive bill that really is going to impact our policies and our practices. And it regards the Senate Bill 1310, use of force. This repeals all the prior statutes relating to when police are authorized to use force and replaces it with new language. Then the officer may only use physical force where there is probable cause. Again, it's that higher standard, that probable cause to make an arrest, effect an arrest, or prevent an escape, or protect against imminent. And the legislature was very deliberate in using the word imminent threat of bodily injury to the officer, another, or a person against whom the force is being used. One significant change in police practices across the state that this is going to affect is for, I don't even remember how long, I think since Terry versus Ohio, officers have been allowed to use reasonable force to detain a person that they have reasonable suspicion. Again, it's that lower standard that I just described in that last slide. If they had reasonable suspicion that a person was committing or about to commit a crime. And it's widely known as investigative detention. Again, it's that case of someone's fleeing out the door and someone's telling the officer, hey, they just took my purse. Do you have, does that amount to probable cause? Well, under reasonable suspicion standard, the officer would be able to detain that person, even if it required a reasonable amount of physical force, to be able to conduct an investigation to develop probable cause to determine whether a crime was committed or whether a crime was not committed. Now that they will not have that ability after July 25th. So their emphasis is going to need to be getting to the scene, developing probable cause. Dispatchers are going to play a huge role in asking more questions to develop probable cause to those officers that are responding, because that is going to determine a number of things about whether or not they can use force to detain somebody. The legislature also left intact in this bill, of course, the ability to defend oneself or another against imminent threat of serious physical injury or death. And again, it's imminent. Imminent is akin to immediate. They have the present ability, and the officer has a belief, a reasonable belief, that the person will immediately cause serious physical injury or death to the officer or to the person. That's a high standard. And then the bill goes on to not only restrict, but then also create a duty of care for police officers. Now, police officers have always had a duty of care, but when in this particular case, they have language in there that requires an officer to exhaust all available and appropriate de-escalation tactics prior to using any physical force. And the bill goes on to give some examples of what that would entail. Time, creating distance, cover, calling for backup or calling for other responders, such as crisis responders, and to leave the area if no immediate harm to anyone or if there's been no crime committed. Again, the officers have always, that's somewhat new, and there's a big conflict of what that intersects with other duties that law enforcement has. For example, RCW 43-185-260 states that an officer shall take into custody a juvenile if they have reason to believe that they're absent parental consent. So that's the typical, the runaway. You have a juvenile, they're in the system. Not all rebellious juveniles that are avoiding their parents are going to go peaceful. And sometimes a reasonable amount of force is needed to bring that juvenile to either a receiving facility or back to under their parental control. There's no authorization for that in this bill. There's incidents under the Involuntary Treatment Act that a person can be involuntarily committed if they're a danger to themselves or others, or gravely disabled and unable to care for themselves. There's a lot of legal discourse right now on what's the implications on that. That's, believe it or not, that's increasingly officers are called more and more to deal with people that are in crisis. And sometimes that involves involuntary commitment. There's pickup orders, and there's a VECA bill, at-risk youth, civil detainer orders that sheriffs serve when people get evicted. There's a lot of incidents, a lot of roles and functions that police are called upon to serve in our community that is not addressed in this bill. And I know I've attended about 4 webinars over the last couple of weeks, same with Andrea and in her legal circles. Of 2 of the webinars were WCIA, our insurer. There's a lot of concern on how this is going to really impact police, at least their expectations and responding to some of these incidents. And of course, police, which they've always been required to use the least amount of force necessary to overcome actual resistance under the circumstances, terminate use of force once it's no longer necessary, once the necessity ends, and have less lethal options available to them. And when possible, use those less lethal options prior to deploying any deadly force options. Further on the use of force, prohibits an officer from using any force tactic that's prohibited by agency policy or law, except to protect one's own life or that of another person. One of the things we'll see several slides up under the certification bill is that that using any force tactic prohibited by policy could be a basis for having their peace officer certification revoked. The Attorney General's office has been charged to develop a model policy on officer use of force by next July. By next July, and then compels all law enforcement agencies in the state to either adopt that policy verbatim or to adopt a policy that's consistent with the AG's model policy. And then we're required to submit copies of our use of force policy to the AG's office, which they will then publish on a website. And then if we make any subsequent changes to that policy, once it's been furnished to the AG's office, if there's any changes, we have to report that to them within 60 days. Law enforcement use of force data collection. This is going to require the Attorney General's office to contract with the institution of higher education to administer a statewide law enforcement use of force reporting system, which is really going to be a database. It establishes the minimum criteria on the types of force incidents to be reported, which under the bill is basically any and all use of force other than what we call empty-handed techniques. An officer grabbing a person's arm, putting it behind their back, applying a set of handcuffs. It includes the instances where an officer points a firearm at an individual, either during a building search or a felony stop or other kind of felony high-risk contact. Those would have to be reported, as well as it establishes the minimum data elements to be reported. So it's going to be, date, time, who, what, when, where, and then all the demographics of the individuals involved. Demographics in the officer, their training, their experience, their ethnicity, gender, age, and demographics of individuals upon whom force was deployed or used. But there's an open-ended caveat that it authorizes the Attorney General to require any additional interactions or data elements to be reported by law enforcement. So the legislature set out the floor. There's no ceiling. The Attorney General can require any kind of information that they see fit. And it mandates that all law enforcement agencies must report the required data and the data elements in the format and the time frame established by the AG's office. So obviously, this is going to have an impact to our staff, their time, their resources to be able to comply with these mandates. Unfortunately, ideally, we'd be able to give them access to our law enforcement records management system or some way to say, here, that's what WASPIC was advocating, don't create more work, unfunded work for all these agencies, find a way to extract the data, causing the least amount of impact. So they're working on that, but there's a lot of different records management systems deployed throughout the state. So it's going to be a challenge.
Chief, just a second. Jason, go ahead.
Thank you, Brad. Would you mind just, reminding council about the tracking that we already do for use of force and why that this being a floor, not a ceiling, could be more problematic? Because it's not like we don't track a lot of this data already. It just may not be in the format that the AG's office would like.
Yeah, right now we're using an internal form that was created even before my time coming back. It's been revised since, but it's a paper form based essentially that the officer fills out, and then it gets routed to their supervisor, to the deputy chief, then to myself, and it gets put into a database that we subscribe to. It's called LEA, Law Enforcement Administration, and we record that data, and that's what I report out every year to the mayor and to the city manager, city administrator, about the use of force incidents, to break them down, as well as accommodations, complaints, and some traffic stop demographics. But it's kind of an older system that we've been using. So I don't know if there's going to be a push towards more of a universal software like Blue Teams, but I'm looking into some different options there. And ultimately, the AG will determine what format and how frequent and what we will report. And that's going to kind of be drive the train.
Chief, can you give me a sort of scale? I mean, I can't remember when you gave me the report the last year, what we were talking about in terms of numbers.
Well, we break them down in 3 different levels of force. Typically, like for example, I think tasers last year, we had maybe 5 or 6. I have them report even when they display it, even if they don't discharge the darts or do a direct stun tase. I think we had maybe like 7 incidents of that, only one of which was an actual deployment. Probably get less than 10 incidents where pointing a firearm at an individual. And then the lower ones are the type 3 use of force, where the empty-handed technique, take people to the ground. And so those are maybe 10 to 15 a year.
Okay, no,
So
thanks.
it's, yeah, I mean,
You don't know what it's going to be like though, because remember, this is, as you said, the AG is gonna set it, and we have a floor now, but it can include more.
no, that's one regard that we are very fortunate, and I've stated that year over year. We've consistently have very low use of force incidents in relation to all our various contacts, from traffic stops to arrests. In years where we've had 350 arrests, we've only had 20 use of force incidents or 17 use of force incidents. So it's
Okay,
extremely low.
okay, thank you. Charlotte has a question or comment. Go ahead, Charlotte.
Thank you. I'm wondering, when you say undoubtedly impact staff time and resources, first of all, I have no doubt about it, but I am wondering if you could sort of educate all of us in which ways, like where you think staff time and resources will be spent in trying to, I want to say accommodate, but abide by these new rules.
Well, that's the unknown, but at some point, unless they're able to go in, find a way to have access to, I don't know. Whatever
Okay.
format, either we're going to have to go in, either we can submit our forms like we have now and let their staff input, take whatever data they want from it. Or what could very well probably happen is they're going to say, here's a website, go in and enter all this information, is what I'm guessing. And they're going to contract, like I said, with most likely WSU to actually administer this use of force database. And eventually they're probably going to post the information to the public with officer identification and subject identification redacted.
Okay, and then I had one more question. It kind of goes back to a summary of some of the information that you brought up on the previous slide. I don't need to revisit it, but I was thinking about how much training an officer goes through, and to the point where it's ingrained in you. Has anyone done it, like a financial estimate on the amount of training it would take to undo some of the training and sort of rewire around new rules and around when you can engage, when you can't engage, etc.?
Well, a lot of that I don't know about the analysis of the cost of the training. I'm sure CJTC has done some of that work. If you go back, rewind back to 2019 in the passage of or 2020, and the passage of the LATASCA, the Law Enforcement Community Safety Training Act, which was a byproduct I-940, requires 40 hours of training, 24 of which is patrol tactics, which specifically addresses de-escalation, time distance cover, and with the goal of decreasing the necessity to use force. And then, of course, all the officers currently attending the academy, they've revised their criteria on use of force to be in compliance with that as well. Does that help answer your question?
It does. Thank you.
Okay, duty to intervene. Senate Bill 5066 requires all general authority officers who witness another general authority officer using or attempting to use excessive force, that described as force not allowed by policy or by law, to intervene if in a position to do so, to end or prevent the excessive force. We already have and have had for many years a duty to intervene. This becomes important because this failure to intervene can also serve as a basis to decertify a peace officer, a mandatory basis. The second thing that the duty to intervene bill requires is all general authority officers who witness or have reason to believe that another general authority officer has committed wrongdoing. Wrongdoing is defined as conduct contrary to law or agency policy that is not de minimis or technical in nature. They have a duty to report such wrongdoing. We have a similar one under our policy that covers codes of conduct for them to self-report as well as report knowledge of any other officer violating our code of conduct policy.
Chief.
Interesting.
Go ahead,
Sorry.
Sharon, real
Yeah,
quick.
my question is a quick one. When you say we, do you mean state or city? Like, there's already state law or city regulation?
These are relating to our department policies.
Perfect, thank you.
Incorporates a duty to render first aid, and labor group was able to get it prohibits discipline for retaliation or prohibits discipline or retaliation, excuse me, for intervening or reporting as required. So essentially it's a whistleblower protection for officers. We want to encourage them to report the excessive force incidents or wrongdoing. Requires the law enforcement agency to report to Criminal Justice Training Commission any discipline resulting from an officer's failure to intervene or failure to report wrongdoing as required by this bill. Again, that's because that can be a mandatory basis for an officer decertification. Requires CJTC to develop a written model policy on the duty to intervene and the duty to report by December 2021 this year, and all departments must adopt their own policy by June 1st of 2022. CJTC must also provide training by December 2023. And that's training that all officers that graduate the academy before January 2022 will have to undergo that training. That means all currently certified peace officers prior to January 2022. Senate House Bill 1088, it's impeachment disclosures, known in legal circles as the Brady. Requires the county prosecutors to adopt a written protocol by July 1st of next year, addressing the types of misconduct that must be disclosed by law enforcement agencies to prosecutors. It's regarding possible impeachment evidence or information regarding individual officers, how the information must be disclosed and maintained. And we've always had a Brady policy and shared information with prosecutors. And what this bill does for the first time is creates a process for which an officer could be possibly removed from a Brady list. So it's not a scarlet letter for their entire career. It mandates that these prosecutor protocols have to be reviewed and updated every 2 years. Agencies must disclose any of the required disclosures within 10 days. And prior to hiring any officer that's a lateral or they have previous experience as a police officer, we must do an inquiry with the prosecutor in which they worked, whether or not they are currently on any Brady lists or have any Brady disclosures. House Bill, yeah.
I'm sorry, Andrew, did you want to add anything to that? Because I know you have some concerns about your staff.
I'll echo what Chief said earlier, that it's unclear how this will impact staff time and our current processes at this point. But the vagueness of this bill is concerning to me because typically Brady material is really well defined. We know what constitutes Brady material. It is a small box and we know when to disclose it. Potential impeachment information is a very broad brush and could include just about any prior report or incident that an officer was involved in. Anything that a defense attorney could use to diminish credibility of an officer is potential impeachment. So that is all to say that we're unsure what the policy is going to look like and what is going to need to be disclosed on every case. But I have serious concerns about how this will impact our prosecuting attorney and our paralegal, because it could be very time consuming, and discovery is already very time consuming. So we'll be tracking this closely.
Before you continue, Chief, Charlotte.
Yeah, along those two notes, I was wondering about all of these. Is there any indication about how much of this will go into rulemaking? Like, is there going to be more specification, or is it going to take new legislation to get the specifics you're looking for?
Good question.
I'm looking for, I don't think it will be a whack. I don't think it'll be an official rule, but these protocols that the counties need to develop and disseminate. And then obviously the collaboration and coordination between city, municipal prosecutors is going to probably be our best guide. So I don't suspect it will result in formal rules, but rather practices that we'll all just follow.
Okay, thanks.
Yeah, and like Andrea said, it was previously Brady and the successor cases, Cowles, I think it is, it was fairly narrowly defined, and it really was any misconduct on the officer that would, affect their credibility as a witness in a criminal proceeding needs to be disclosed. And that typically dealt with issues for truthfulness or untruthfulness. And so we don't know how far that's going to be expanded. And we know, and we'll get to in a few slides, a lot of conduct. The CJTC has been given a lot more mandatory and permissive decertification for different types of conduct. So that's part of what's kind of somewhat concerning. So this is a completely new Office of Independent Investigations. That this was a governor's priority bill or request bill, I guess they call it. It creates the Office of Independent Investigation within the governor's office. And it's designated as a limited authority law enforcement agency, although none of whom can be law enforcement. They will all be civilians. There initially has to be at least 2 years separation from employment as a law enforcement officer to being an employee of the Office of Independent Investigations. And then after 5 years, that phases out to where they're going to be completely civilian. Beginning July 1 of next year, the Office of Independent Investigation will be authorized, but not required, to investigate the use of deadly force by any law enforcement officer that occurs on or after July 1, 2022. It's important to know the distinction between they may, but not required. They get to pick and choose. And so the impact to us is that right now we have our county independent force investigation team, which is made up of law enforcement members from throughout Pierce County. That doesn't go away. So the state did not relieve cities and counties from their obligation of having an independent force investigation team that was part of the Latasca I-940. But they're creating a separate entity that would have kind of concurrent jurisdiction. This bill actually requires that law enforcement agency immediately notify them of any deadly force incident and to relinquish the scene of an incident to the Office of Independent Investigations if they choose to assert jurisdiction. And then, of course, duty to comply with any request for information. One of the troubling aspects with this is I've been talking with Waspic and other police chiefs is that what we found in officer involved shootings, if there's an underlying crime that led to the use of force incident, typically what we found is those two incidents are inseparable. Or if you have an incident like say in Puyallup, their recent officer involved shooting that stemmed as a welfare check, and there was appeared that the wife had killed her husband and was refusing to let family engage in a welfare check for the husband's well-being. Ultimately, that ended up into an officer involved shooting at the residence. So it would be to have a force investigation team only do the officer shooting, where you've got a homicide that took place inside and the person accused of the homicide is the person law enforcement engaged in deadly force with. It would not look good for Puyallup to still investigate that homicide. So they're really inseparable. And so there's a lot of questions about having an, it's not as simple as just saying, well, we'll have this completely independent office come in and investigate police officer deadly force incidents. Sometimes they're much more complex than that. And so like an incident of Puyallup, the IAT, they did the entire investigation. And we find that that's being more common than not. This is an independent of independent investigations. So like I mentioned, under our current law, each jurisdiction has their own independent force investigation teams. For us, it's the PC FIT team. This bill authorizes the state auditor to conduct a process compliance audit of any independent deadly force investigation. However, they exempt the new state Office of Independent Investigations. They don't, governor wasn't going to allow his office to be audited. That's to ensure that the independent investigation teams are fully complying with the I-940 requirements of being an independent investigation team. A new element is at the request of the Criminal Justice Training Commission, the state auditor can conduct an audit of any law enforcement agency to ensure that that agency is in compliance with all laws, policies, and procedures governing training and certification of peace officers employed by the agency. That's completely new. Now, the legislatures did prohibit the auditor from charging the law enforcement agency for the audit. However, as we all know, it can attest that there's a lot of staff time in preparation to, in response to an audit. And of course, that is unfunded. I believe the state auditor's office itself estimated that for every $3 the auditor spends in doing an audit, the entity being audited spends $1. So there's quite a bit of costs and staff time involved with that. And that takes effect this summer as well. This is a kind of a big expansion. The Senate Bill 5051, it's known as the decertification bill. So in Washington, all peace officers are certified by the State Criminal Justice Training Commission. And typically in the past, certification can only be revoked following an agency investigation and a determination that an officer was dishonest, which is pretty broad ranging, or had been convicted of a felony. This bill expands what CJTC will mandatorily and what they may discretionarily decertify, and also gives them the ability to suspend certification, to require an officer to undergo training, or to put their certification in a probationary status for up to 2 years. Besides the expansion, and I'll highlight a few of those in a moment, one of the things that's particularly concerning is that in the case of a suspension, there's no time period limitations. The legislatures did not put in up to 6 months, let's say, up to it. There is no time limitation at all. They do talk about probationary status for up to 2 years. And this is labor, through the various labor groups in Washington, were able to have the legislature put in a proviso in this bill that the employer may not take adverse action based on a suspension of their certification. An employer may take adverse employment action against underlying conduct, right? If an officer did something, violated policy, maybe they were given some form of discipline, I have to report that discipline to CJTC. CJTC says, well, we're going to suspend that officer's peace officer certification for 60 days, let's say. Okay, what are we to do with this officer for the next 60 days? Have a highly compensated phone operator? So it's very problematic. CJTC may conduct its own investigation into the allegation of improper conduct independent of an employing agency investigation. Another interesting thing with this bill is that there's a proviso in there that CJTC may suspend, revoke, decertify, regardless of any appeal, whether it's through an arbitrator or through an appellate court, reversing the employer's discipline. So let's say I terminate an officer, they arbitrate it, they get reinstated, and then CJTC comes back and goes forward and decertifies them. That's a huge conflict. What do we do then? Do we employ an officer does not have a license to be a peace officer? So there's a lot of, I understand the intent, right? I understand the legislature's intent to increase accountability, to have more authority over peace officers' certifications, licensing. But there's just a lot of unanswered questions in this bill. CJTC, really they've gone from being a accrediting and training organization to being an overseeing organization, to being a police accountability organization. They're specifically authorized to receive complaints directly and to conduct their own investigations into allegations of misconduct. CJTC can issue public recommendations regarding law enforcement agencies' command decisions, their policy or training, investigations or discipline, potential systemic violations of law or policy, or unconstitutional policing or other matters. WCIA has a lot of concern about that, about what kind of implication this may have towards civil liability. It expands the requirements relating to pre-hire background checks, which I think is probably a good thing. More inquiries into officer affiliations with extremist groups. Of course, I mentioned the Brady List. Requires law enforcement agencies to report within 15 days any use of force incident that results in death or serious injury. That can also now be a new basis for suspending an officer or decertifying an officer. And it changes the composition of the commission from, it was 14, they added 2 last year to 16, and now it expands it to 21 members. They're eliminating law enforcement positions to create additional positions, adding 7 new civilian positions. And before we had legislatures. We had the attorney general, we had elected prosecutor, chief of the state patrol, and we had a number of labor seats, a number of police chief seats, a number of sheriff seats that comprised the initial 12-member panel, or excuse me, 14-member panel. And then they added 2 additional citizen seats to 16, and now it'll go to 21. It's going to be interesting, that dynamic, and to get consensus from a rather large commission.
Chief, I started looking at all the administrative additions to the commission and everything else. I mean, was there any action taken in terms of, budget, staffing, et cetera? Because, if you leave the way things are, you can't do all this extra stuff. This is a huge increase in terms of overall responsibility.
Yeah, there's no way that CJTC is equipped to take on these mandates. Certainly not by when they become effective, which the majority of which is July 25th of this year. So what the legislatures did was put in a requirement that the director of the Criminal Justice Training Commission needs to report to the governor by December of this year the various impacts that this is going to have in expanding their role. And a lot of that, I'm sure, is going to be tied to budget. Now, the biennium budget is already passed. I think they added $27 million to create the Office of Independent Investigations. I don't know what specifically CJTC was allotted to help staff up to meet some of their new mandates. So obviously, I mentioned earlier that previously, and I serve as a hearings examiner for CJTC on decertification hearings. When the state does take action against your peace officer certification, you have a right to a hearing, and that didn't change. But what did change is typically it had to be final. The discipline, the investigation finding and discipline had to be final. So it had to go through appeals, exhaust any remedy that they had, and be a final determination. And it was solely on the grounds of some sort of dishonesty or untruthfulness. That's now expanded to conviction of any felony offense, convicted of a gross misdemeanor DV offense, or convicted of any crime that has sexual motivation. And convicted, and these are mandatory decertifications. Convicted includes Alford pleas, nolo contendere, and also deferred prosecutions. So they could be terminated if they were terminated or convicted of a use of force resulting in death. If they failed to intervene or report excessive force when in a position to do so under the prior bill's mandate, under duty to intervene, that could be a basis to be mandatorily decertified. It's not discretionary based on the circumstances. It's mandatory under this bill. And if they were terminated or found by a court to have knowingly made false statements, that was the previous basis. Or if they're prohibited from possessing a firearm under state or federal law, or are the respondent in a permanent no contact order. Some of the discretionary decertification or suspension of their certification includes excessive or unlawful use of force. Any type of sexual harassment is defined by state law. Any fraud or misrepresentation used for personal gain. Any statements verbally, on social media, in writing, or any gesture involving prejudice or discrimination. If they have any affiliation with any extremist organizations, if they've been found to have committed any felony offense without regard to their conviction. There's a question on what standard of proof that they are going to use for that. If they're engaged in any pattern showing intentional or reckless disregard of constitutional rights of others. unsafe firearm practices. And then they really have kind of a catch-all. It's basically conduct unbecoming or any unethical conduct that would discredit law enforcement. And it's fairly all-encompassing. Gives them a lot of discretion. So the legislature gave CJTC some teeth to enforce this. They're authorized to impose a civil penalty of up to $10,000 for the failure of either by an officer or an agency failure to timely and accurately report any of the information that's mandated under this bill to the Training Commission.
Chief, before you go on, Cindy has a question. Go ahead, Cindy.
Sure.
Chief, is this bill 5051, this decertification, is its intent to weed out undesirable officers and make it impossible for them to ever be in that field of work again? Is that the bottom line of this?
Well, I think moving forward, its intent is to, bring more accountability to the profession. Now, like Andrea and I, as attorneys, we're regulated by the bar and ultimately the Supreme Court, and they have the ability to, reprimand, suspend, or cancel our bar license, right, based on certain prohibited conduct. So this is kind of more in line. It's giving them more ability because there is inconsistencies in how different departments deal with disciplinary matters. There is inconsistency with arbitrator results in arbitrating discipline, and a future slide speaks to that as well as a remedy. And to hold them more accountable, in addition to them being accountable to their employer. So they're saying, okay, Sumner, okay, Puyallup, okay, Spokane, we're a state agency. We issue these peace officer certifications, and they're now going to take a more active role in their ability to suspend, revoke, or even in some cases require remedial training. So they are in a lot of ways acting in the place of the employer in some of these matters. Does that answer your question?
Yes, it does. Thank you very much.
The bill requires law enforcement agencies to retain personnel records for the duration of the officer's employment plus minimum of 10 years thereafter. That is a huge change. And it's any relating to any discipline. So any record of counseling, written reprimands, things that typically through our former collective bargaining agreement would not end up permanently in an employee's personnel record, now statutorily is mandated to be included and retained. Excuse me. And there's a mandate that officers have to disclose it. And that's part of the expanded background checks, is that we have to inspect officers' personnel records. And their CJTC, talking about transparency and accountability, they're required to maintain a publicly searchable, machine readable, whatever that means, exportable database on certifications and discipline overall police officers throughout the state. WSBA does a similar thing. You can go on the WSBA website and search for lawyer discipline, and it would be included in there. Specifies that CJTC shall have sole authority to provide basic law enforcement training. Over the years, some of the larger agencies such as Seattle, Spokane have wanted to do their own academies. So that kind of forecloses that legislatively. And then it prohibits law enforcement agencies from considering any applicants. Oh, sorry, skipped one. law enforcement agencies are required to conduct and complete administrative investigations even when the officer retires or resigns prior to them completing the investigation. So that's not uncommon where there's an allegation, the department starts to investigate it. And in the course of that investigation, the officer just says, you know what, I quit. And then from the employer's perspective, unless it involved an allegation of dishonesty, if it was some other sort of policy violation, further investigation would be fairly moot, right? Because we'd investigate it to determine what kind of discipline to impose. But if that officer is no longer an employee, it becomes somewhat moot, and a lot of agencies would end their investigation and look to hire that officer's replacement. Well, now we have to complete the investigation, regardless if they retire or resign prior, and submit the results of that to CJTC so they can take appropriate certification action. And then it prohibits law enforcement agencies from considering application for employment unless an applicant waives all prior confidentiality agreements. And they have to execute waivers, which we have them do now. Employers, former employers of an officer cannot conceal no sealed settlements, no sealed discipline, no sealed separation agreements. It's all full fair game. So we want to not hire an officer that may have issues in their back. This is another huge change. House Bill 1223. It's called the Uniform Electronic Recordation of Custodial Interrogation Act. This is basically a de facto body cam bill. The legislature is going to require, effective January of next year, that any custodial interrogation of an adult for a felony offense or a juvenile for any offense that takes place in a jail or a police facility must be audio and video recorded to be admissible. Custodial interrogations that occur in a police vehicle or a school must be at the minimum audio recorded. And officers must document.
Chief, just a second. Patrick has a question. Go ahead, Patrick.
Thank you, Mr. Mayor. And I will do my best not to sound like I'm on a soapbox here. I just wanted I tried to catch it before it went into the body cams, but I wanted to commend you, Chief, and Andrea and the department for maintaining your professionalism and optimism as trying to sort through this list of bills that directly impact your day-to-day operation. And I pair that with my disappointment in the short-sighted political and reactionary nature of the majority of these bills. I have no doubt that the best practices and common sense items throughout these bills are already adopted through policy through the department, and those changes are welcome with the new bills. But there are a lot of items in here that are, again, speaking for myself, that I think many of the writers and or sponsors of these bills either do not understand what officers do on a day-to-day basis and the risks that they undergo, and that they're also, or that they're not concerned as much with the officer's safety as they are the offender's best wishes. So it's a highly politicalized item for the state. I wish there was more thought put into these bills and less reactionary response. But I thank you and I thank the department for taking them as they come and trying to work through them the best. So I had to say it out loud, and it's driving me insane as we go through these bills, some of the things that were included in them. and again, I speak for myself, but I think it was a horrible, or many horrible pieces of legislation that were either incomplete, or poorly thought.
You're probably not alone in those feelings, Patrick. Go ahead, Chief.
Okay, and thank you for that. Trying to cast aside my personal feelings on some of these matters, and also just for council, I've taken that's kind of a slow and deliberate approach to this. That's part of the reason why this is coming so late. We're almost into July, is that there was a number of trainings and info sessions and a lot of discussion and debate at WASPIC and in person and in webinars and and all the legal counsel for all cities and counties and their respective groups of WASAMA and WAPTA, and we've really trying to work deliberately through the implications of these bills, and some of them, quite honestly, we still don't, and so that's the first step, is understanding what the legislature meant and how's it going to impact our operations. Then my next step is policy formation, and that's going to occur in the next 2 weeks. Like I said, we just finished our last WCA meeting last Thursday. I believe Andrea was in that as well. Now we're going into policy development, and then on July 22nd, we'll have a mandatory all department training on much more of the specifics. So they'll have the benefit of, this is our new policy, this is what the mandate was, and this is how it's going to affect us moving forward.
Chief, yeah, I agree with a lot of what Patrick said. It seems to me that a lot of things that came out are, just like in a lot of things, are reactionary to events that have happened. But anytime you have some reactionary type of legislation, you end up with unintended consequences, because you don't know what the impact is really of the things that are being legislated. And to throw all the things in terms of responsibilities to CJTC, that whole thing is just, I could see all kinds of problems coming up in that one. But then to form the independent, the Office of Independent Investigations, but fully fund it, but leave it totally discretionary in terms of what things they take on, I just go, wow. I think it's going to be up to a lot of the agencies to really document some of the problems and issues that they're facing. And hopefully future legislative sessions will start addressing some of those, issues as they come out.
And WASPIC was very engaged this last legislative session. We brought on an additional lobbyist, spoke to most of these bills. Some bills, the sponsors had no interest in hearing our voice and would only take written. But in many of these things, it's not like they didn't know. Okay, they were told, well, that officers will no longer be able to stop someone. Yeah, we know that. Yep, we know that. And either we know that and we don't care because it's more important to get these reform measures, and we'll work on the details later. It was mixed with varying degrees, but it's in many of these bills, I can't remember if it was the use of force bill or at least the police tactics bill. I mean, that initially wanted to take away canines for police application. I mean, there was probably 30 some, proposed amendments to that bill. So a lot of these got, a lot of changes were made, but yet there's still left a lot to be desired. And some aspects raised more questions than they answered.
Yeah, thanks, Chief. Go ahead, Jason.
Thanks, Mayor. I was going to say this comment to the end, but it's timely right now. We talk about the need to retrain our officers. We have some officers who've been doing this 20 plus years, and these are some significant changes, particularly in the areas of use of force and what they can and cannot do. But I think what needs to be said too is it's also retraining the public. What are their expectations when they call 911? Because we may not be able to respond as we typically have been able to. And, with time, I think things will flush themselves out and there'll probably be some modifications to this. But we're seeing other cities around us take some very conservative approaches to policing. And I don't want to say call it deep policing, but they're definitely limiting their officers' ability to respond to calls based on these new laws. And it's something that I think the public will have to get accustomed to, that, we may not respond in the same manner that we have been responding in the past. Reform is necessary, reform is important, but it's going to take some time to get used to the new normal.
Thanks, Jason. Go ahead, Patrick.
Thank you. Just a quick comment on what Jason said is that's one of the things that infuriates me the most is because of those restrictions, the officers being, I don't want to say hand-tied, but their drive and their want is to go out and serve the public and protect people and help solve issues, and not being, what is that going to do to our officers and telling them you can't do those things anymore? I'm not saying everything in general, it's just going to stop, but I fear that we are going to have consequences from these bills that are going to create public injury and public harm in the long run.
Thanks, Patrick. Go ahead, Chief. I see we're on slide 16 of 29. So, Barb, did you have? Go ahead.
Just wondered, are you going to educate the public, like in the weekly newsletters, let them know maybe that there will be changes, or is that just too hard to, it's some kind of message seems to go out.
Yeah, the problem is, and it's hard sometimes to develop a bright line rules. We won't go to these calls anymore. We won't go. There's so much gray, and that's part of what we do. I'll tell you that the Puyallup incident started as a welfare check. Haven't heard from my son.
Yeah.
Wife's having some issues. Go there to check. She won't let him go check. Please get called. Okay. I'll tell you, and Bill knows from the South Sound 911, monthly we get a dashboard, and it shows us what our top 5 calls for service are. And in May, the second highest one was welfare checks, 3,500 across Pierce County. Whether it's somebody shooting up and passed out behind the wheel in a parking lot, to, someone didn't go to work, to, hey, I think, so that's a significant service. And many of those aren't criminal in nature. They're more of our duty of community caretaking. And yet there's possibility and probability that a use of force incident can result from that. So some agencies are taking a hard line. We're not going to these unless certain elements are there. Like I said, that our old mantra, no call too small, and we deliver personalized service here. We really have to look at that in our exposure to civil liability. And so it's Andrea and I will be working on a lot, over the next course of several weeks as we further develop our policy on response to calls. So moving on, like the Mayor suggested, and it should only be 19 slides. The Uniform Recordation Act. So any felony in custodial interrogation or juvenile for any offense must be recorded if it's conducted inside a police facility or a jail. So this is going to have an impact on, we have 2 interview rooms in our police facility. They used to have a standalone recording system. When that system wasn't supported anymore, we just tied it into our DVR system that's got all the videos of City Hall, the back parking lot, the front door, the lobby, upstairs, etc., BAC area. But after knowing that this bill was coming, I had our IT department check and see if the audio and visual, and they learned that there's no audio recording in those 2 interview rooms. So this is definitely going to require us to have an upgrade to our audio and video capabilities in those 2 interview rooms. As far as the BAC area, because any felony of an adult, depending if you've had prior DUIs, you could have a felony DUI. And of course, we ask interview questions relating to their use of alcohol and driving. That needs to be, because it's in a police facility, audio and visual to be enabled to be admissible in court. Now, there are a few exceptions, like I point out here, any spontaneous utterances, excited, exigent circumstances. If the person being interviewed refuses to do so, if they know it's being recorded, interviews outside of Washington, that would be like a detective going to Idaho to interview a homicide suspect or something. If there's safety concerns, that's particular to confidential informants, or if there's good faith, but the equipment malfunction.
Hey, Chief, just a second. Barb has a question. Go ahead.
Well, what is BAC? Just
Sorry,
so I understand.
that's in our booking room. We have a blood alcohol concentration device known as a
Oh,
trigger.
okay.
So
That helps to.
yeah,
know
sorry
what we're
about that.
talking about.
Barb, it's a good thing you didn't know what it is.
Yeah, it's a good thing.
Well, so far.
So this is going to have huge impacts. And Waspik legislative heavily saying this is a body cam, de facto body cam requirement. And they said, no, it's not, because they know if it is, that the legislature's got to provide funding for it in the budget. House Bill 1140, juvenile access to attorneys. This mandates that an officer must provide a juvenile, that's any person under the age of 18, access to an attorney prior to any waiver of any rights. If they detain the juvenile on probable cause for any criminal offense, if it's custodial interrogation, or requests any consent to search a juvenile's person, property, dwelling, or vehicle. This right to access to an attorney cannot be waived by the juvenile or a parent. Any statement made without providing access to an attorney would be suppressed. So it would not be admissible in court, any subsequent court proceedings. And then the bill requires the Office of Public Defense, the State Office of Public Defense would be the agency responsible for providing access to attorneys for juveniles. And the biggest concern here is that the Office of Public Defense is sorely understaffed and underfunded to meet this mandate. I don't know of any defense attorney that wouldn't properly advise their client not to speak or not to give consent for any searches. So effectively, there really won't be a whole lot of interrogation or questioning of juveniles going on relating to any criminal cases moving forward. They would need to be provided access, and that's 24/7 access, most likely by phone. There's more rural areas of the state where there's other issues such as cellular connectivity and different things, but that's now going to be a requirement effective January 1st of next year. This is the Blake decision, the fix to the Supreme Court, Washington versus Blake decision, Senate Bill 5476. It amends the Uniform Controlled Substance Act to now specify that knowing possession of a controlled substance is a simple misdemeanor. So the city ordinance that you all passed, I think in like April, is now preempted. This new definition under Uniform Controlled Substance Act is effective when signed, so it's effective now, but it does sunset July 1st of 2023. So there'll be 2 other subsequent legislative sessions between now and then. Part of the new law is that law enforcement must, not may, but must divert for referral for assessment and services an individual found in possession of controlled substance at least twice before any violation can be referred for prosecution. So they get 2 attempts to refer the individual for assessment and services. And then, of course, one of the challenges is tracking and sharing that information. I'm happy to say that Pierce County, South Sound 911, we're on a uniform RMS platform, report management system. So we added a new call type code for unlawful possession referral, so that it can be tracked that way. And then a new search option in our RMS for drug referral. So an officer can put an individual's name in, check that box, and do a quick search. So at least in Pierce County, we'll be able to share information regarding our contact with individuals. Our policy is to write a report, seize the narcotics, do a field test, presumptive test that they are in fact controlled substance, and then to do the referral through the Washington the recovery helpline, which is a 24-hour, 7 days a week referral service. The new bill also modifies drug paraphernalia statute, removes any reference to paraphernalia that's used to store, conceal, inject, or otherwise introduce controlled substances into the human body. So essentially only paraphernalia that's used to manufacture drugs will be illegal under this new bill. So the city's ordinance that was recently passed by this council regarding drug paraphernalia would now be preempted by the state statute. And of course, requires the state healthcare authority to establish a statewide substance use recovery services plan and recovery navigators. But again, that will take some time, of course, a whole lot of money. And quite honestly, there's just not enough substance assessment and treatment options out there. This is a new civil cause of action. I think it's very important just to understand that now it'll be called into question who called the police and why. So this establishes a new civil cause of action for damages against any person who knowingly causes a law enforcement officer to arrive at a location to contact another person, if it's with the intent to infringe on that person's constitutional rights, unlawfully discriminate against that person, cause the other person to feel embarrassed, humiliated, or harassed, humiliated, or embarrassed, cause the other person to be expelled from a place in which the other person had a lawful right to be, or damage the person's reputation or their financial, economic, consumer, or business prospects. And this allows for any prevailing party, any prevailing plaintiff, can recover not only economic damages, which are somewhat hard to prove in some of those underlying causes, but they can also get non-economic damages and punitive damages and attorney's fees and costs. So neighbor calls the cops on you, please show up, that you're being too loud. Apparently, if you can prove that the neighbor called the police to for one of those unauthorized reasons, you could sue your neighbor for calling the police. So this is going to have a, the potential chilling effect on people even summoning the police if they fear that they may be accused of having some other motive for calling the police. And the last couple slides are just some quick summary slides, just for your awareness. There's House Bill 1320, that's 320-page bill. It repeals 137 existing statutes dealing with protection, different types of protection orders that can be issued in this state, and consolidates them all under a single area of section of law. And this is really just going to require a lot of work, where that different references to the old RCWs are throughout our policy, or if they're on any forms that we use, those all need to be updated. 5055 establishes a rotating pool of specialized law enforcement grievance arbitrators within PERC, Public Employment Relations Commission. And this is, again, changes kind of the way things have historically been done regarding grievance arbitrations, where the employee, labor union, city draw from a list and then alternately strike names until they agree upon one. That's no longer an option. It's going to be, they're going to have a rotating pool of at least 9 to 18 arbitrators that undergo specialized training dealing with law enforcement. And you're just going to get whoever's next. Requires school districts to, there's a House bill requires school districts to adopt certain policy and procedures regarding safety and security at schools. And if you have an agreement with law enforcement, like for SROs, like we have, that needs to be submitted to the OSPI, Office Superintendent of Public Instruction. It doesn't say what they can do, what they have to approve it or not. It just says we have to provide it to them. House Bill 1227 modifies the criteria authorizing law enforcement when we can and must take a child in protective custody without a court order. That's another one of those obligations of law enforcement that use of force is not specifically authorized, but typically those situations don't require a use of force. There's now going to be a statewide 988. I think Bill's familiar with this because South Sound's gearing up. It's going to be a new behavioral health crisis response line. That with it comes an additional tax on current phone lines to fund the crisis hotline centers and their response services. It'll be similar to the 50-cent 911 excise tax you pay now. Senate Bill 5038 bans open carry of firearms or any weapons on the state capitol, but also within 250 feet of any public demonstration. So that could potentially, those are fairly loosely defined. It could potentially affect us. There were several bills that affect licensing, driver's licensing policies in Washington. One is licenses will now be good for a period of 8 years. You'll have the ability to do remote picture capturing for when you renew online at home. Drivers receive an infraction will have 30 days to respond rather than 15 days to the notice of infraction. And there will no longer be any suspension of your driver's license for failure to pay fines. There's a number of bills that address corrections reforms, most of which deal with early release, what the state calls reentry plans for offenders. And that includes sexually violent offenders housed at the McNeil Island facility. And one little glimmer in the 22-23 biennium state budget, the legislature provided $20 million to offset costs of implementation of all these police reform measures the legislature passed. So on a per capita basis for Sumner, that would be roughly around 40,000. There you go.
You can't make this stuff up, Chief.
Yeah. And that was buried. We had to find that. We found that. Somebody found that. I think AWSC.
Oh, they found it for you. They didn't let you know.
Yeah.
Great. Well, it's a
They
huge
don't
amount
want
of
you to
money.
know, so you don't request it.
Yeah. Well, it's a huge amount of money for what we have to do. Wow. No, I'm just shaking my head. There's a lot there. It's going to be challenging. And I think we're going to learn a lot. Unfortunately, not in a good way over the next year. Let's see, I'm looking at anybody else. Okay, Patrick, go ahead.
Just a quick follow-up to my statement earlier, Chief. I support you and the department and the job that you do, and I am sorry that you have to go through so many of these hoops. I'm trying to keep it polite. So many of these hoops just to go through about your day-to-day public service.
Yeah, thanks, Patrick, for saying that. Yeah, Chief, I was glad because I did look at I'm following along in the agenda and the packet. It has, we're still on page 21 of 29, and I'm saying, thank God you didn't have another 8 pages because it was overwhelming as it was. And thank you for distilling it down into things that are, somewhat digestible and understandable for me. But I don't know. Yeah, I feel for you and Andrea and Jason and all the police officers and everybody in the criminal justice system of having to try to navigate this. It's going to be a challenge.
Yeah, it's definitely going to force us to rethink, how we respond to calls and what calls, and, trying to, collaborate as much as we can with our other law enforcement partners so that our policies are somewhat consistent, particularly in East Pierce County. I think we've got similar communities and their expectations of our police. And recall that duty to report misconduct or duty to report excessive force is in the eye of the officers' policies, their department policies. So if our officers go to Puyallup, we're backing them up on a call. They have a duty to report based on our policy, which may be different in Puyallup, and maybe not. Likewise, if Puyallup's backing us up. So that's a little bit problematic as well. I think it puts officers in somewhat of a difficult position. So we want to make sure to the extent possible that our policies are pretty similar among the agencies. And you'll be happy to know that my next presentation on body worn camera updates, only 4 slides, 4 slides and 2 quick little videos.
Okay. Well, I don't see any more hands raised. So why don't you jump into body cams? Go ahead, Chief.
All right. So this is gonna require some more screen sharing and multitasking on my part, which those two things don't always go well together.
Yeah, you navigated the last session. You can do this one. I know it.
But it might get tricky when we come to the videos. I
Yeah.
had to download those. So I wanted to update the council where we're at since we first met March 8th and did a presentation regarding the body cameras. And here's a little timeline since the March 8th. So I posted the draft policy of our body worn camera to a special Sumner Connects webpage that Carmen created for me on April 28th with the goal of soliciting public input regarding the use of body worn cameras in our policy or proposed policy. And we also, Carmen promoted that on our social media, in our e-news, Facebook, Twitter, etc., to try to drive people to that site. We've had absolutely no public input. Had no emails or input on it. As far as how many times it's been visited and that sorts of things, Carmen would likely have that analytics. But as far as response, we've had none. And it had a bunch of FAQ. It had links to our March 8th presentation. If you haven't seen it, Carmen did a great job on that website. May 3rd, Council passed Resolution 1582, which authorized the use of body-worn cameras by our officers, which was strongly encouraged to do so under our current RCW. And it also gave me authorization to work on the operational policies with community input, which we did on the Sumner Connects site, and to commence or further explore the procurement process, which I've been working with Axon. I've got a new development I'll share with you in just a moment. May 10th to June 7th, our officers, we received our field trial kits. So it was a camera and all the necessary hardware and charging cables and docking stations and all that good stuff, as well as access to the evidence.com cloud where the camera images are stored on and managed from that platform. And so we had 4 different officers wearing 4 different cameras. They were the body 3 cameras, and it generated, there's 73 in there, but some have been officers playing around or some of our record staff redacting. And so when you do that, it preserves the original, but then also creates a new one so that you can keep a copy of what was disclosed or provided public records request, et cetera. So it never deletes that information unless you go in and delete it. Got very good input, feedback from the officers on the ease of use, and the quality of the videos is really good. And that's why I want to try to be creative here and share some of that with you. This is a video of an officer doing a traffic stop at night. Can you all see that? I'm gonna figure out. Oh, let me back it up. It's been playing. So the camera buffers for 30 seconds before the officer activates it. So the audio doesn't come on until 30 seconds. And this is a nighttime video. I just wanted to show you kind of the quality. So that beeping noise, you just turn the camera on. It buffered back 30 minutes. It's going to call out on a traffic stop. It's got very good nighttime quality. So, an officer bends over to approach the passenger window. That's a bad side effect. You get some. So that particular person was stopped for speeding. He works out in the north end. It's 3:47 in the morning, and his excuse was he had to use the bathroom. So
I'm glad it wasn't a red truck.
yeah. So that's a frequent, got to use the bathroom, frequent one. Now I've got a daytime one to show you some quality of a daytime traffic stop. This is Officer Eller. He's working the Valley Meadows stop sign. Residents complain that people don't stop. So he's out there working.
We never hear about that one.
Yeah. So again, this is in the buffer mode. This is showing up the time before. And then the audio will kick in right at 30 seconds.
Hey, you know I stopped you? Yeah, you need to stop you. That's your driver's license.
But it's got excellent, it's just got really good video quality. I was really impressed at it. And this is at the 780, not the 1080. This is at the high def, but not as high as it can go. And it's got extremely good, good quality. Both the driver and the passenger.
There we go.
Yeah, it's attached to their chest. So unfortunately, if they bend over to and are facing down, the camera is going to be facing down.
Chief, just a second. Charlotte has a question. Go ahead, Charlotte.
Sure.
Thanks. No, so the video was really impressive. Is the 30-second audio delay standard?
So yes, and we can change the buffer. 30 is the minimum, and it goes up to 2 minutes. But 30 is kind of the industry standard. And what I've seen in the video I've reviewed, it catches back whatever incident prompted them to turn the camera on, like a traffic stop or a subject stop.
And I forgot, and this makes sense because right when is it correct that usually when you tap it or turn it on, the video rolls back 30 seconds?
Correct.
Okay, then that makes sense for why you'd have a 30-second no audio.
Yeah.
During that time. Okay, sorry, putting 2 and 2 together now. Thanks.
Go ahead, Patrick.
The choppiness on the replay, is that the rebroadcast by sharing it on the web, or is that the camera recording?
You know, I did a sample run with this with one of my on-duty sergeants earlier. He asked the same thing. So I did not, when I'm viewing it, it is clear as crystal clear.
Okay, so it's the
you know, other than-
rebroadcast onto the webinar.
Because it's attached to their body, you're gonna get the, you know, this kind of motion when they're walking. You're gonna get the, you know, staring at the ground if they're bent over with their head in the passenger side window so that they can hear because of passing motorists or whatever. You know, it's not gonna be perfect.
No, and in rebroadcasting a video onto a video conference degrades the stability on it quite a bit. So no, I totally
Okay.
get that. Just you saying that you're viewing it was crystal clear that's, if we were to download it, it would play perfectly clear. So yeah, that makes sense.
I think
Yeah.
you're running into buffering issues when you run it back through this thing.
Oh, okay. Yeah, unfortunately, I'm not on your side of the screen to know how it looks, but from my side, it looks really well. And those were two that I went in and picked intentionally that didn't have any minors in it or, you know, anything that would need to be protected or redacted. But you know, all the videos have been extremely high quality. So those two videos, I actually went into the Axon Cloud account. So my choices were I could open up the cloud, share that screen and play the videos from there, or I downloaded a link to my email and then just saved them on my computer. It's that simple. So back to our slide on where we're at now. All right, let me start from scratch. Okay, so we did the field trial, got very good feedback. Couple of things that have come up in talking to our sales rep and something that happened here. So every year our TASER instructors download data to, they have access, as TASER instructors, they have Axon accounts and they go and they download every TASER device in the department and do a check on them. Well, this year, when Officer Eller did it, he found that 12 of the 24, and we have 24 because we also equip our 3 ACOs with them and all officers and detectives, including myself, are issued TASERs. 12 out of 24 of those were from model year 2015 or prior. And actually one unit goes all the way back to 2010, so it's 20 years old. Axon will not support any TASER over 5 years. They don't issue firmware updates. They don't fix them. They throw it away and buy a new one. 7 of those had malfunctioning LED displays. The LED display gives the officer information about what the current battery storage is and any deployment information on the back of the TASER. Another incident that happened April 11th of this year in Brooklyn Center, Minnesota, which is a suburb of Minneapolis. There was a unfortunate mistaken TASER deployment where the officer pulled their Glock firearm rather than their TASER, and it resulted in a death of a motorist. One of the issues that came about on that was not only how the officer carried it, but the resemblance in appearance. All our current TASERs are black they in color, and so is our Glock sidearms. And one of the things that after the April 11th Brooklyn Center incident, they had every sergeant inspect their officers to make sure that they were carrying it in accordance with their policy. And when I started to inquire with Officer Eller was talking to our TASER rep on the other side, going over the issues with our TASERs, and mentioned that we were looking at body cameras. And they said, we have a program that's called Core Plus that's only available for agencies that have 100 or less sworn officers. And it's a bundle package of TASER 7, which is only available in neon green. TASER does not produce any black composite TASERs anymore. They're all going to be neon and very distinguishable in appearance, shape, and size. And the newest Axon 3 body They both use the evidence.com cloud storage. The new tasers have a lot of really desirable features, not only in the way they deploy, but in their capabilities in shorter and longer span deployments. They have some distinguishable characteristics. And also they have the ability to what they call this dock and walk. So the brains are in, right now, these are disposable batteries. To connect the device to the Axon, you have to use a USB cord. These would dock in a docking station to recharge, and it would automatically download the taser data. So every time an officer deploys a taser, they're required to download the taser activation. It'll tell me how many cycles at what time it was deployed, and they attach that to their use of force report. But unfortunately, the only ones that can do that are our current taser instructor, Matt Eller, who would have to wait till he's on duty next, use the USB cord to download it. This downloads just like a body cam. As soon as they put the taser battery in the charger, it uploads to their Axon account all their deployment data, as well as any updates in firmware or software for the device itself. And the taser and the body cams, they talk together. They have Bluetooth technology that when a taser is turned on and activated, it will also activate a body cam. Doesn't require purchasing any other device. And so I looked into this Core Plus plan, and there's a number of features that come with it that before, when we looked at body cams only, that were a la carte features that we would purchase as add-ons, such as the triggering device on our side arms, our firearms holsters, unlimited storage in the cloud, a number of features that we feel would be desirable. The tagging comes with training. So the bundle combines both the taser and the camera. And it's based on $159 per officer per month for a period of 5 years. So the annual cost for that, and we'd still look at deploying 18 cameras. That would cover all our patrol officers and our community service officer. Then there's required licensing for redaction, some additional licensing for non-camera wearers. Every body cam comes with an access license because that's how they tag, they manage their videos, they can watch their videos. But we need additional ones for other staff that deal and have a business need to have access to the videos, right? Whether it's public records requests, reviewing complaints, or managing the evidence, the storage of the evidence, the retention of the evidence. So that requires additional fees per year. And then, of course, sales tax. So this Core Plus plan of both 18 TASER 7 tasers and 18 body worn cameras with cloud access would be roughly $42,100 per year. So the 5-year contract would be $210,000. I strongly suspect that as demand across the nation and definitely the state increases, I think their cost is going to increase as well. So this quote is, asked for a new quote. I did identify a licensing an error in the last one. I have not received the newest Axon quote, but it'll be good through September. But I know that other agencies around us are looking at body cams. And Jason can speak to that as well. I know he meets with other city administrators and in groups, and between the body cam requirement, the recordation requirement, the desirability to be more transparent and accountable to our community, I think the time is right for us to deploy body cameras. So my next act will be probably a future budget amendment, Jason.
I love it when the city administrator is having technical difficulties.
Swear it, too many screens. Yes, a budget amendment and then an authorization to purchase because of the dollar amount over the 5 years does require council action. So you'll see the budget amendment at the end of July or the first meeting in August, and as well as procurement probably on the same meeting.
Okay. Patrick, go ahead.
Yeah, I just want to say, not only from this presentation, but this happened to be the topic on the night I filled in for Josh on Public Safety Committee, so I got a good briefing on it. I really like the idea of the combined package and the way that Chief explained it.
Yeah, thanks, Patrick. Go ahead, Josh.
There is some cost offset also because we're not buying tasers anymore. Is that right?
Yeah, if we were to outright purchase the 12 that are aged and obsolete, it'd be about 40 grand. And so that's roughly about the amount of increase from the a la carte body cam only package to what this new combined package is. And we would get the benefit of having 18 new tasers. And I mean, there's a video I could show you. I'm kind of a taser geek, but there are some really beneficial factors for the officer using these tasers. In just the way they deploy, the science behind them, and the way that they function. Yeah, that could be a whole nother presentation.
Yeah, Chief, I really want to thank you for, I think, getting ahead of the game on this thing, because I agree with you. I think that other agencies, well, like you said, they're looking into them now. They're not as far along as we are. And I think you've come up with a very reasonable, good approach, and something that will, I think protect our officers more than anything down the line. So good work. Go ahead, Andrea.
Thanks, Mayor. I have two quick comments to make. The first is that Chief just did an excellent job of explaining how body cameras are a wonderful tool for law enforcement, for accountability, for transparency, for public trust. But I want to just point out and add to that these are a wonderful tool too for prosecution. It is really difficult for a jury to look at a body cam video and discount what they just saw. It is much easier and much more common for them to discredit testimony on the stand. So these are a really nice evidence tool for prosecution, both to acquit defendants, right? If they really say it wasn't me, it was my brother, we can prove that with this footage. And we can also discredit defendants' testimony with these. So they're a really nice tool for the back end of law enforcement, which is the prosecution. And then I would be remiss if I didn't also mention that body cameras come with quite a bit of additional personnel impact. If we get a public records request for body camera footage, it must be reviewed and redacted appropriately. There's a whole lot that body cameras can capture that is not subject to public disclosure. Sometimes in people's homes, things get caught on camera that shouldn't be disclosed to the public. It's not in the public benefit. And so the redaction software that comes with these body cameras is probably the best available on the market, but it is still very clunky. I have a colleague that mentioned to me that it took 8 hours to redact 15 minutes of body camera footage because you're blurring faces, you're catching minors, you're blurring backgrounds in some situations. And so I wanted to say all of that to prepare counsel for the fact that this may require additional records personnel. It certainly will require a whole chunk of time for either PD records or the legal department. Currently, legal reviews and redacts every email that leaves the city in a records request. And so it's likely that these video redactions will also be a primary duty of the legal department. So I just wanted to set up this conversation and let you all know that it comes with a lot more work on the back end.
Very good points. Thank you, Andrea. Other questions or go ahead, Chief. I go back to you. You have any additional stuff to share, Chief? Or
Nope, that's pretty much it. We're still kind of in the tail end of negotiating the body cam policy with our labor union. So that's we'll see how that goes. I think tomorrow's another session. So, but we've had the opportunity for the public to weigh in. I think we're pretty close on policy. I'm going to need to update it to now that we know some of the workflow and some of the more procedural things that we've done the trial period. And so I think the next step is to acquire the technology and deploy it, and in kind of following the same timeline where we have department training on November 3rd, I believe, for deployment.
okay. Well, generally, I think that you've seen head nods around the table, so I think your next step is bringing that purchase item, the contract back to the council, and I appreciate, Andrea, your comments. Heads up as to down the line is that it isn't just the $40-some thousand per year and stuff. It's the additional labor cost and impact on staff, which you're going to have to assess. And then, between you and Jason, okay, wait a minute, how do we deal with this, as we go along? Because I know you're already slammed as it is with everything, that you have on your plate, let alone the additional PDRs associated with body cams. So thank you. Okay. Wow, Chief, I'm glad you didn't have item number 3 down there. That was one heck of a lot of information, and obviously is one of those topics of more to come as they start working through all the issues that we've been blessed with from the legislature this session, and mindful of Patrick's comments. So anyway. Thank you again. Okay, move on to City Administrator report. Mr. Wilson, go ahead, Jason.
Thank you, Mayor. Just 2 quick items tonight. First and foremost, just a reminder, next Monday is a holiday and there will be no meeting the following Tuesday. So enjoy the week off and a 4th of July. And second, Michelle sent out an email regarding the Puyallup Sumner Chamber of Commerce Economic Lunch. It's scheduled for Thursday, July 29th, starting at 11:30 in the morning. The city did reserve a table. If you're interested in attending that, if you could get back to Michelle here within the next week, that'd be appreciated so we can make sure that we have enough seats for everybody. And that's it.
Thank you very much, Jason. Agenda setting in terms of city council meeting agenda items and committee meetings, issues, problems. You're all leaving town. You need coverage. Anything going on? I don't see anything. People look like they're worn out. Wow. Well, the good news, everyone, is that it is now down to 100 out, from our 106 that we reached today. So it's cooling off. Although my check-in with home says it hasn't cooled off enough. If you need to, nope, we're past, sorry, the sprinklers are turned off. They were turned off at 7 o'clock, but you can set up, well, I guess you can't, Charlotte. Anyway, I could put a sprinkler in our front yard, Charlotte, if you want to run through it. You could do that. Just don't get any police response where they're having body cams on and on a trial basis. Anyway, I prattled on enough. Okay, executive session. I hope we don't have one of those tonight. Do we, City Attorney? God, good answer. Thank you. Okay, with that, seeing as you've all done a heck of a lot of work, and thank you, Chief Mwerke and the rest of staff for your great work. There's no more business before the council. We are adjourned. It is 8 p.m. Tomorrow will be a cooler day.
It'll be frosty in the 90s.
And it's going to seem wonderful, which is really weird. Anyway, take care, everyone.